Hello, everyone. Thank you so much for joining us today on our webinar is being hosted by the Agricultural Consultant Committee for Education. We have joining us today Kristine Tidgren. She's the director for the Center of Agricultural Law and Taxation at Iowa State University and an adjunct associate professor in agricultural education. Her work focuses on studying and interpreting laws impacting the agricultural industry. In particular, she focuses on agricultural taxation. Thank you so much for being with us today, Kristine, and I'm going to hand it off to you.
Great. Well, thank you so much for having me. It's a pleasure to talk about what is going on in the environmental law space. I am an attorney and work with agricultural law and teach an agricultural law class as well. I do a lot of work in taxation, but agricultural law is really the focus of our center. And so it's a pleasure to speak with you today. Now, what I've done is just taken three topics that are very key right now, I think, in what's happening across the country in the world of environmental law. And today's goal is really to give you exposure and a background because all three of these topics, there is a lot going on. There's a lot that's going to continue to go on. And so we're kind of going to stay a little bit on the surface. And my goal is to educate everybody on this call enough so that you are able to know what to look for as you see different headlines coming out, that type of thing, because it seems like weekly there's some new development in at least one of these areas. And there's a lot of change going on too. This is one of those areas that, with a change in administration, every time there's new heads of the EPA or the USDA, a new president, different policies get unleashed. And so right now I'd say we're sort of in that place where the policies of the current administration are just becoming evident because we've been in this place for about a year and a half, and that's when new rules start to come out and that type of thing. So we're going to kind of go through the National Environmental Policy Act developments. NEPA is a big deal for a lot of different areas in agriculture. And so we're going to talk about the significant changes that have taken place in that area. Also, Clean Water Act is always an issue, and now is no exception. So we're going to look at the new regulations for the definition of waters of the United States. We're also going to look at why it matters. So I will review with you the last Supreme Court case that we had in this area that's really paved the way for the new direction there and how that impacts owners of agricultural land. And then finally, we're going to close with what's happening with PFAS or PFAS, the forever chemicals, essentially. There's a lot of work going on right now in the administration to carry on what was taking place before this administration took over. So we're kind of starting to see how different things are going to evolve with PFAS as well. It's a really big deal for agricultural producers to understand this kind of emerging area of the law. And so let's start now with the National Environmental Policy Act. And I just want to give a background for some of you that may not be really familiar with how this is in place, what it does, and all of that. And so you probably heard the word NEPA. You probably heard environmental assessments or environmental impact statements, EIS. Those are the terms that are thrown around. But this all comes from a law that's been in effect since 1970. So the National Environmental Policy Act was actually the first real environmental law that we had. Now, we had some previous laws that dealt with the environment and things, but this era of the early 70s was a time when our country kind of got serious about the need that, okay, our water is in bad shape, our air could get harmed, we need to do something. And so NEPA was really the first step in that series of new legislation that was passed when President Nixon was in office. And the purpose of this law was, as stated, to declare a national policy to encourage productive and enjoyable harmony between many and his environment. So these legislative purposes always sound really lofty, but essentially what NEPA was intended to do was anytime there was an infrastructure project that was either built, funded, or approved by the federal government, it required the federal agency that was responsible for that project to prepare what's called an environmental impact statement. Now, you might have heard of that just as an EIS. A lot of times you hear about, oh, we're waiting on the EIS, right? Because these things have historically taken a very long time. And the EIS has to address the significant environmental impacts of a proposed project. And then it is also supposed to identify any feasible alternatives that could mitigate those effects. Now, we're going to talk about in a minute the very strong limits of this law. This law does not go very far, but in terms of what it actually impacts, its impact is very broad. So in the agricultural space, any federally permitted projects. So if you have a large CAFO that's required to get an MPDES permit, if you are trying to build or do something on a wetland, the land use changes, those will all require an EIS or an environmental assessment. Now, why is that if it's not the federal government that's building it? Because all of these permits and things are approved by the federal government. So again, all the things that we'll talk about later as well will impact the stretch of the NEPA policy. For example, waters of the United States, right? You only have to have an NPDES permit if your wetland is considered a waters of the United States. So all of these policies sort of fit together. So again, like I said, NEPA is often considered our first major environmental law, and it was passed before the Clean Air Act, before the Clean Water Act, before the Endangered Species Act. And you can kind of see that reflected in the fact that NEPA itself does not have a lot of regulatory teeth. Its meaning and function has really, though, in the last couple of years, been severely transformed, or significantly transformed, I should say. Perhaps severely curtailed is a more appropriate way to say it. And so the place we kind of start when we look at what are the changes that have happened to NEPA and how does this impact the availability of an environmental impact statement, for example, is we have to look at the agency or the council that was created by this legislation back in 1970. And it was called the Council on Environmental Quality. And usually you just see it referred to as CEQ. Now, when this agency was created, it's not like EPA. EPA was established and set aside to be an agency that is creating regulations. EPA is responsible, for example, to administer the Clean Air Act, the Clean Water Act. The CEQ is an agency of a whole different variety. The duty of this agency was to assist and advise the president, gather information about the quality of the environment, and analyze whether current trends are interfering with the goals of this NEPA law. And then CEQ is supposed to, by statute, recommend national policies to improve environmental quality. And then it's supposed to review activities carried on by the federal government to see if they contribute to the purposes of NEPA. So if you read that through today's language, it doesn't sound like CEQ has a lot of authority. However, in 1978, President Carter, he issued an executive order, and all of a sudden he gave CEQ the authority to issue formal regulations implementing NEPA. Now, again, this wasn't a congressional action. This was simply an executive order. And in 2020, CEQ updated the regulations for the first time in years, and pursuant to an executive order in 2021 by President Biden, they modified the rules again. And it's interesting, the rules were finally implemented in 2024, and they really expanded public involvement in the EIS process. They imposed some time and limits and some page limits on the EIS. And they also told the agencies like USDA and the EPA and the Army Corps of Engineers that they were required under NEPA to take environmental justice and climate change into account when they were issuing the EIS statements. So kind of interesting in the scheme of all of this all happened in the backdrop of the US Supreme Court case that was sort of brewing. And so we're going to get to the actual decision that didn't come for several years, but the US Supreme Court addressed NEPA for the first time in a case that really arose with facts in 2020. And it was when the 7-county infrastructure coalition applied to the U.S. Transportation Board to approve an 88-mile railroad line. Okay, so this is how the EIS process usually occurs. Okay, we're going to build a railroad, and so we're going to get approval from the U.S. Transportation Board, the USTB, and the railroad line that we want to build is to transport crude oil to refineries along the Gulf Coast. And so in response to NEPA, the board prepared an environmental statement, EIS, and it addressed significant environmental effects of the project. And it identified feasible alternatives that could mitigate those effects. So the USTB did exactly as instructed by NEPA. It proceeded to do a lot of work. It drafted this EIS, it invited public comment, and all this took place. It had 6 public meetings. It took more than 1,900 comments, and it prepared a 3,600-page EIS that analyzed numerous impacts of the railway's construction. Now, remember, this is an 88-mile stretch of railroad. Now, this environmental impact statement that was prepared by the U.S. Transportation Board, it noted in the 3,600 pages, but it didn't fully analyze that there could be some potential environmental effects of increased upstream oil drilling in the basin above where this rail line was. In other words, okay, we're going to have this new rail line, so now there'll probably be increased drilling, so that too will have environmental impacts and increase downstream refining, right? So kind of the supplemental or the tangential effects of building the line, not the environmental impacts of building the line itself, but from the fact that the railway line was going to be there, there would likely be some additional environmental effects. And so in the end, after doing all this work, took a very long time, the board did approve the railroad line, allowed the private railway company to continue, and concluded that the project's transportation and economic benefits outweighed its environmental impacts. So it seems as though, the Transportation Board followed the statute, the outline of what the statute requires. Now, in the process of this, a county in Colorado and a couple of environmental organizations, they filed a lawsuit against the National Transportation Board, saying that they had violated the NEPA in many different respects when they issued the EIS. And they got the DC Circuit Court to agree with them. And what they said is, the board, when they created this EIS statement, they impermissibly limited the analysis of the environmental effects. They didn't include a detailed description of all of the new environmental impacts that would result from the upstream oil drilling or the downstream oil refining. And those effects were reasonably foreseeable, and they should have been included in the EIS. So after all this time, the DC Circuit vacated approval for the railroad entirely by saying that there were deficiencies in the EIS and the board had to start over. Now, they appealed the decision and the US Supreme Court reversed. And so this decision came out in the summer of 2025. And this decision is very significant in terms of what it lays out with respect to what's required for an EIS, what is the authority of the agency CEQ. And so we're just going to kind of walk through this because this ultimately is very impactful to future environmental impact statements. So the court said the board was entitled to substantial judicial deference and that the court incorrectly interpreted NEPA to require the board to consider the effects of the upstream and the downstream projects. They said this is unacceptable. They also pointed out, because I showed you first off what NEPA actually required, and the court affirmed that. They said NEPA doesn't mandate results. All it does is prescribe a process for an environmental review of a project. And the whole purpose of NEPA is just to make sure that the agency and the public are aware of the environmental consequences of any proposed infrastructure projects. And so agencies are to be accorded deference when issuing an EIS. Now, if some of you are familiar with Loper-Bright, which was a decision that came out of the US Supreme Court a couple of years ago that said, hey, we need to decide law ourselves. We can't just defer to the judgment of an agency. This is a totally different situation because here the US Supreme Court, in interpreting the law, says the agency is just given entire deference by this law to determine how they choose what an EIS should look like. And so here, the choices that the Transportation Board made with respect to the EIS that they issued fell within what the court said was a broad zone of reasonableness. And so agencies just simply have to explain in the EIS that they have addressed environmental consequences and the feasible alternatives. And there's no place in this law for a court to micromanage an agency's decision as long as they've actually basically created an EIS and on its surface, they did everything they're required to do. And so the court made a couple of important statements. And I will say right here, this was a unanimous decision by the US Supreme Court. This wasn't one of those 5-4 decisions, anything like that. All of the justices agreed. And they said that NEPA has been transformed from its roots into a modest procedural, as it was supposed to be, a modest procedural requirement. And it was transformed into being a substantive roadblock that paralyzes agency decision making. And ultimately, if you're one of those developers who's awaiting an EIS, it's paralyzed development as well. And so the court said NEPA does not allow courts under the guise of judicial review to delay or block agency projects based on the environmental effects of other projects that are separate from the project at hand. And so this case also came. There have been NEPA regulatory challenges outside of the Supreme Court case. So the Supreme Court case just said, hey, agencies have complete broad discretion. But there have been several other federal court cases that have said, you know what, CEQ, they've got no regulatory authority at all. So I want to point out the couple of cases here, and states like Iowa were very heavily involved in initiating these lawsuits. So the first case that came up was the Marin Audubon Society versus the Federal Aviation, the FAA, and that was decided in 2024. And the DC Circuit Court there said that the CEQ doesn't have any rulemaking authority at all. So remember, I told you that the CEQ had actually initiated and had issued final rules that had governed how agencies were to go about the EIS process. And right here, this court said, those are invalid because NEPA doesn't give the CEQ any rulemaking authority at all. And then in 2024, states led by Iowa also challenged the CEQ authority. And the North Dakota District Court also said that CEQ lacks authority to issue any binding NEPA regulations. So basically, what CEQ has the authority to do is to just offer direction and non-binding guidance. So then that was affirmed in January of 2025 when President Trump took office and he signed an executive order. It was called Unleashing American Energy, and it directed the CEQ to provide guidance on implementing NEPA to expedite and simplify the permitting process. So the idea was, okay, you can't issue binding rules, but what you can do is to encourage all of the federal agencies to find ways to make the issuance of an EIS a more streamlined process. In July of 2025, the Eighth Circuit Court of Appeals then dismissed the Iowa and the other states' lawsuit against CEQ. They dismissed it as moot because they said, okay, the administration is already in the process of rescinding the rules. So in September of 2025, CEQ rescinded its rules and issued non-binding guidance. So now here's where we stand, right? With NEPA's requirements, you don't look to CEQ for regulations. The agencies are all responsible in their own right to come up with guidance. Now, we also have had Congress in here fiddling with NEPA as well. And of course, all these things I think have arisen from the huge amount of time it has been taking to get these environmental impact statements. And it has been growing over the years to where it had sort of become somewhat of a crisis. And so in 2023, Congress did revise NEPA in the Fiscal Responsibility Act. And in there, they said, okay, we've got to have some page limits and we've got to have shorter review times. This cannot take as long as it's been taking. And then last summer, with the One Big Beautiful Bill Act, they created an opportunity to have even more expedited NEPA reviews. Here, an applicant can pay money, 125% increase, of the cost, so 25% more, and they're guaranteed to have expedited timelines. And so if you pay that extra money, if you have just an environmental assessment, which is less extensive than the environmental impact statement, it's required for things that aren't supposed to impact the environment as much, it's guaranteed to be 6 months. And for the environmental impact statement, it's supposed to be able to be turned around in 1 year. And so in response to all of this, and I realize this is a lot, but I just wanted you to see the breadth of everything that's been going on with respect to NEPA. The USDA realized that it needed to issue new regulations because everybody had just been following the CEQ guidelines. And since that no longer existed, in April of 2026, so just a couple months ago or just last month, USDA issued their final NEPA regulations. And they also said that all of the different USDA branches, so FSA and all of them will use the same rule. And so the public process is limited to statutory requirements, is what the USDA says. The only publication that's going to be required is at the time when there's a notice that will be issued that they're going to prepare an EIS, and then they'll request comments, but there'll be no other notice or comments required under these regulations. And the USDA is not required to address all of the comments, just the ones that it deems to be the most impactful. And so if you're interested in this at all, you can go ahead and click on that link or take a look at that link. I'll be providing these slides after this session. So in sort of a roundabout way, the current status of NEPA is this: it does not impose substantive environmental obligations or restrictions. It's simply a procedural statute. No weighing of impacts is required, and the agencies have discretion as they reasonably see fit. And so the job of NEPA is just to inform agency decision-making, not to paralyze it. That was from the US Supreme Court case in 2025. So the EISs, the EAs, they still have to be completed, but in the wake of all of this change, timelines should be shorter and there's less opportunity for judicial review. So if somebody wants to challenge it, it's unlikely that the courts will shoot down anything that comes out of a NEPA review. So that's NEPA. And I want to move on because we've got a lot going on across the board in environmental law. So the next topic I wanted to talk about was what's happening with the Clean Water Act. And so just give you a tiny bit of background, most of you are very familiar with the Clean Water Act, but this was renamed, significantly amended in 1972. It was another one of those key pieces of environmental legislation that went into effect during the Nixon administration. And the stated purpose of this law was to restore and maintain the chemical, physical, and biological integrity of our nation's waters. So what you see there is a picture of a lake in Ohio that exploded, right? Because there were no good regulations that prevented the dumping of things like oil and things into the waters. And so Clean Water Act was desperately needed. And so in response to all of this at its core and how it impacts our agricultural producers as well, and anybody that is out there discharging things into the water, the Clean Water Act prohibits the discharge of any pollutant or any fill material into navigable waters without a permit. And so navigable waters has been renamed or interpreted to be waters of the United States. Now, why is it waters of the United States? Because the only jurisdiction that the Clean Water Act has, is water that is subject to the jurisdiction of the US government, which means it has to have some impact on interstate commerce, which is most water. But there is definitely some water that does not have that impact. And so part of the controversy of defining what water is jurisdictional has just been, what reach does it have? What is actually waters of the United States? What is not? And so WOTUS, as many of you know, has been the source of great consternation for many, many years in terms of what it actually means. And so today I'm going to tell you about the little bit of increased certainty that has been brought to the table because of a recent Supreme Court case. And now we're going to get final regulations that sort of implement that. So stay tuned, we'll get there. But I want to talk about why it matters. So the first thing is the prohibition against discharging pollutants through a point source into WOTUS. And they can't have that unless they have an NPDES permit. And so the permit will contain limits on what they can discharge, monitoring, reporting requirements, other provisions to ensure the discharge doesn't hurt, water quality, people's health. So that's the NPDES permit. The term pollutant is broad. And this is why in the agricultural world, we've had to really keep on top of this, because the term pollutant includes even something like soil. So I dig up soil and I put it back and it goes into the water indirectly, directly, or I'm on a wetland that's water of the United States and I dig up soil. That is actually a pollutant, right? So if it's being discharged through a point source, then that's when an NPDES permit is required. Now that's a 402 permit. We have some agricultural exemptions that say if it's stormwater discharge or return flows from irrigated agriculture, we're not required to get an NPDES permit. So we're not required to do that. So that's fine. Large CAFOs are point sources. They are required to get the NPDES permit. And so that is an important permit in the agricultural world, although a lot of CAFOs fall under the limit of needing one of those permits. The other big portion, though, of the Clean Water Act is the issuing of permits if someone wants to fill material, like go dig. So this would be development. I want to build a barn on my property, but my property is considered a wetland. Even though it doesn't look like a wetland, I don't see any cattails, but in the past, I didn't know if it was a wetland or not. It's very confusing. And so for this particular purpose, who you would need to get a determination from would be the U.S. Corps of Army Engineers. And if you are on a U.S. wetland, you would be required to get a Section 404 permit before you could do anything that would involve dredging, digging, putting fill material on the ground, that type of thing. So if you did not know that it was a wetland and you went ahead and did it, you could be subject to very significant penalties. If you seek a permit, the permitting process is very extensive. And so several years back in a prior US Supreme Court case, the justice said, the average permittee spent 788 days and $271,000 to seek a permit. And if you don't get a permit, then you can be fined up to, I say here, $68,000, but it's gone up. So I think it's over $70,000 per day. And you can be subject to criminal penalties as well. So this is some pretty serious stuff, knowing whether or not your land includes waters of the United States. And so that's been a huge question for several decades because the guidance hasn't been clear. Some US Supreme Court decisions haven't been clear. They've led to more unclear guidance. And basically, we've gone back and forth as different administrations have taken over to say, what is waters of the United States? And so what I wanted to tell you about this morning was a case that came out from the US Supreme Court in 2024 that I believe has finally shed some significant light as far as giving us a little more certainty. Now, nothing's ever going to be perfect, but I think that we now have a lot more clarity with respect to what actually is waters of the United States. And so this case arose, the facts, way back in 2004. So it's not a typo, right? The case was decided by the US Supreme Court in 2024. So this was a 20-year saga for this family named the Sacketts. And they had purchased a 0.63 acre lot in Idaho in a housing division. So this wasn't an agricultural producer. This was somebody that wanted to build a house, and not a very big lot, just over a half an acre. And the lot was 300 feet from a large navigable body of water called Priest Lake. And I'm going to show you a picture here in a minute, but I want to tell you, like, between the lot and the lake, there was a major road and there were other homes that were built. And so as they began backfilling the property with dirt and rocks to prepare for the construction of their house, the EPA informed them that their actions violated the Clean Water Act because their property contained protected wetlands. And so protected wetlands are waters of the United States subject to jurisdiction. So the EPA said, hey, you have to restore this site or you're going to be threatened with penalties at that time of $40,000 per day. Now, it's indexed for inflation, so it's a lot more now. But here is the picture of what this looks like. So the up here, the box at the top here, the little rectangle that says Sackett property, if you can see that, that is the property they purchased. You can see there are houses beside them. You can see there are houses in front of them. And you can see there's this big body of water that is Priest Lake. And so the property was adjacent to an unnamed tributary on the other side of the 30-foot road. The tributary led to a non-navigable creek, which in turn led to this big body of water called Priest Lake. And so the EPA, because of that, they said that the Sackett's wetlands were similarly situated to what was called the Kalispell Bay Fen, which was a large nearby wetland complex. And I'm reading you all this. I think it's interesting because I want you to see the complexity with which these cases have been determined. And so based on this analysis, the agency said, yep, you illegally dumped soil and gravel into waters of the United States. You are subject to significant liability. And so the Sacketts challenged this first to the district court. The district court ruled in favor of the EPA. So then they challenged it to the Ninth Circuit Court of Appeals, and the Ninth Circuit U.S. Court of Appeals also ruled in favor of the EPA, and they said, okay, the EPA followed the test at the time, which was a significant nexus test to decide whether or not the Sackett's land was a wetland that was considered waters of the United States for purposes of the Clean Water Act. And so there you be. And the Sackett's did not stop there. They appealed to the U.S. Supreme Court. Now, what the significant nexus test had come from was a case that if we'd had more time, I'd have walked you through that one. But it was a case from 2006 that was Rapanos versus United States. That one did involve an agricultural producer out in the West Coast who had tried to use development on land that was considered to be a wetland. And the court at that time had constructed this significant nexus test, which was not clear at all, which said, oh, okay, if your land has a significant nexus to other waters of the United States, then you are also waters of the United States. And that's why I read you that complex list of the tributary that went to the tributary that went to the Priest Lake, because that's the type of analysis that was required to be done. So the Sackett's challenged their ruling to the U.S. Supreme Court, and they boldly asked the court to overrule Rapanos and to come up with another test. And the test they asked the court to adopt was a test that Justice Scalia, whom I'm sure you're familiar with, the Supreme Court justice that was in place for many years, and in the Rapanos case, he had suggested, and 3 other justices had agreed with him, but it wasn't adopted as the law, that the test for a wetland to be waters of the United States should be that that wetland have a continuous surface water connection to other regulated waters. In other words, there should not be dry land between the water and the navigable water. There should not be dry land between the Sackett property and Priest Lake. There should either be clear wetlands all the way or streams and rivers that flow onto the property. That's essentially what they asked the court to do. And so there was oral argument and everything went to the Supreme Court. And in 2023, the U.S. Supreme Court significantly narrowed the definition of waters of the U.S. And I want to tell you that all 9 justices agreed. This was not one of those cases. Now, in the end, with the actual test, we have a 5-4 split. But all 9 justices agreed that the EPA had gone too far, saying that the Sackett's property was subject to Clean Water Act jurisdiction. All of them agreed that the Sackett should not have had to get a permit and that they were deprived of fair use of their property. Now, the actual holding, though, it did take away the significant nexus test. And this was authored by Justice Alito, and this was a 5-4 opinion. So this was not a unanimous opinion. But the rule that the Supreme Court declared was that adjacent wetlands, in order to be waters of the United States subject to federal jurisdiction, they must have a continuous surface connection with traditional interstate waters. And that is the rule the Supreme Court issued. So right away, President Biden was in office at that time. And in response to this case, the Biden administration did have to create a conforming rule. And so they revised the definition of waters of the United States. That rule was published September 8, 2023, but it was challenged in court because anytime you have a new rule that deals with waters of the United States, you can guarantee there are going to be legal challenges. And so that rule actually never went into effect because of all of that litigation. Now, when President Trump took office, then it was that administration's duty to come up with a rule as well. And so on November 17 of last year, right at the end of last year, the EPA and the US Army Corps finally announced their proposed rule. And this proposed rule is their version of what Waters of the United States rule needs to look like after the Sackett opinion. And so here's the highlights, but essentially what it does is it does restrict which wetlands can be subject to federal jurisdiction, which means it restricts which property can be required to get a permit before you're able to build, before you're able to dredge, fill, that type of thing. And so what it does is it defines relatively permanent. And so, in order to have a continuous surface connection, there has to be relatively permanent water that connects your property to whatever the known waters of the United States is. And so the term focuses on those waters that are standing or continuously flowing year round, or at least have water during the wet season. And so this is tributaries, lakes, ponds. Some of them might dry up during a particular season, but that doesn't mean they're not waters. As long as there's usually water there during the wet season at least, then they will be considered water that can connect a particular property to other waters of the United States in order to create jurisdiction. Also, it defines continuous surface connection to fully implement Sackett. This term would require wetlands to meet a new two-part test. One, they have to abut other jurisdictional water. So that's easy. If the Sacketts had been trying to build right there on the lake itself, like right there, then that would have been met. Or they must have surface water at least during the wet season. And here the Sacketts did not have any surface water, so they did not meet this test. And then the rules for purposes of agricultural producers, they would also clarify what constitutes excluded prior converted cropland. It allows the agencies to identify prior converted cropland and ensure that it only loses that designation when it's been abandoned and it reverts to wetlands. So what is prior converted cropland? Well, before we had all these rules, before 1985, before all this, we were able to drain and crop basically any land that we wanted. And so the rules have always allowed that any cropland that had been previously drained, it's not like the agencies were going to step in and say, oh, this used to be a wetland, now you have to convert it back to a wetland. That's never been the law. So the law says, and these proposed rules confirm, and if we get final rules, I'm sure they'll go along with this, that you can only lose the status of prior converted cropland, which would, if you lose the status, then it means you can't farm it anymore. But you only lose that status if you stop farming it, you sort of abandon it, and you allow it to go back to being a wetland. So all of a sudden, you've got your cattails again, and you've got water standing, and you haven't farmed it. Now you're not going to be able to drain it. It is now back to being a wetland. So that's what that means. Now, the other component of the Clean Water Act, so what we were talking about is the regulation of wetlands, which require the 404 permit, and the regulation of point sources, which require the 402 permit. But there's a whole other swath, of course, of pollution that is not regulated by those two particular sections of the Clean Water Act, and that's non-point source pollution, right? So everything we do basically generates some sort of non-point source pollution. In the agricultural space, of course, this can occur from runoff from animal feedlots, from cropland that's fertilized, and of course the nitrates run off into the water. If you are fertilizing a golf course, if you're fertilizing your suburban home yards, the city streets that are just dirty with grime and muck, and the rain falls and it all just runs into water, that is all forms of non-point source pollution. So how does the Clean Water Act regulate non-point source pollution? Well, this one has really been coming more and more into the public view as of late. And so what the EPA says is that non-point source pollution regulation is primarily state-led, but the EPA always has the backstop. So the EPA is sort of the umbrella, but the states have the authority to be in here figuring out what to do. And so define water quality goals, complete data information assessments. The states are required under what's often referred to as Section 303. They are required to assess the status of their waters, and they are required to list impaired waters. And the impaired waters are on a public list. And for those impaired waters, they are required to create what's called total maximum daily loads, which restrict the amount of pollution that can actually be in those waters. And so different states have different approaches, and Iowa is no different in terms of being required to create a list of impaired waters. And then how to go about fixing all this is typically been voluntary action that is promoted by the state. So in Iowa, for example, that's where I'm at, we have what's called the Iowa Nutrient Reduction Strategy. It's been a partnership between the state and different groups and the university and all of that. And so the state is required to do all this that I just showed you. It has to be updated every 2 years. And then if the state does not provide the TMDL that it's required to, then the EPA must step in. So that is in the Section 303 statute. And so, there's all kinds of things, like we said, that end up in the rivers and lakes and streams and all of that. The Mississippi River Gulf of Mexico watershed, that was established in 1997. The problem is all this nitrate and things coming from farm fields and things as well. It can end up in places like the Gulf of Mexico, creating low oxygen levels. If the water has high nitrates, it's it can be dangerous. So treatment plants have to take it out before it can be safe to drink, all of those things. And so this is just a little background on the Iowa Nutrient Reduction Strategy. But what I wanted to tell you about is there's new action going on, and there have been other lawsuits like this as well, but I think that some environmental groups have really started to look at non-point source pollution. So I think that what we're really going to see is an increased push for the EPA to step in and take control over some of these Section 303 regulated waters. And so the most recent one actually was filed last week here in Iowa. The Food and Water Watch, the Iowa Environmental Council, the Environmental Law and Policy Center, they filed an action directly against the EPA, and they said that the EPA has not performed its required duties in regulating Iowa water quality. And so there's a lot of background there, but essentially Iowa was required to create a list of impaired waters. The list was created and included several waterways that then were taken off of that list by the EPA last summer. And so because of that, these groups are saying, wait a minute, where did these go? These are waterways that have lots of nitrates in them. And the question is, do nitrates count in terms of requiring a TMDL, because they have to be taken out of the water before the water can be drunk by large cities like Des Moines and stuff. So how are they not on the list of impaired waters? That is the question that the lawsuit poses, and we'll definitely be seeing some more developments. This one is filed in the Southern District of Iowa. So again, it's a new lawsuit. Stay tuned to see what happens. But again, we've had a lot of developments, and we always do, in the area of the Clean Water Act. Now, the last topic I wanted to talk about with you today is a little four-letter acronym that I'm sure you've heard of, but this one too, you're going to hear a lot more about this in the years to come, because this is really becoming something that is the focus of a lot of attention, and it's PFAS. So if you're new to this, like, what the heck is PFAS, right? So the scientific name is per and polyfluoroalkyline substances. There's also PFAS is another acronym, but clear as a bell, right? That's the molecular structure, if we have any chemists out there. But basically what most of us know about these chemicals as is forever chemicals. So these started coming out in the 1940s, and they are manufactured chemicals that have really transformed industry for a very long time. No one really thought about safety for many years, because they did not realize that, oh, wow, once you create this thing, it never leaves, and then all of the waste from it stays in the environment. And what does it do? Does it have any negative health effects? Because it's in the blood of people and animals all over the world. Now, when I gave you this very easy thing right here, it looked, oh, it's straightforward, it must be one thing, but there are thousands of different PFAS, and some were more widely used, more widely studied than others. And the question has been, because no one really knows. Now, this is from the EPA, where they have started to study, are PFAS safe? And there's not a very clear strain of evidence yet that proves, but more studies have been showing that even low levels of exposure to PFAS can lead to cancer, to weight. They could be part of the cause of obesity. They can reduce immunity. They lead to some developmental problems like low birth weight, things like that. And also, they have been shown in some studies to decrease fertility, increase high blood pressure in pregnant women. So there's been more and more look at the safety, and the research that has been done has not been very encouraging, because it has shown that, oh, it doesn't take large levels of PFAS to have some of these impacts. And so where is it? And the answer is kind of, it's everywhere. And so it's in drinking water. It's, of course, at landfills and disposal sites. That's a given. One of the big sources, crazy enough, is fire extinguisher foam. It's a big source of PFAS. Facilities, all the things that are involving textile, paper manufacturing, lots of PFAS from that. All of our non-stick pans, paints, sealants, all those things that resist heat, resist grease, resist water. The reason they do that is because they're this PFAS chemical. And then food packaging, almost all of that has been just filled with PFAS. And then the topic I really want to talk about is biosolids, because this is the area that has really impacted, I think, the agricultural sector, and will continue to impact agricultural land. And this is where there, I think, will be some significant changes in the years ahead that we will be paying attention to. So we're going to come back to biosolids. But the other place where PFAS is found is, of course, fish caught in water, livestock. Like, again, it's everywhere. But the biosolids, this is what happens when wastewater treatment plants they take the sludge that is left over from the treatment and they create a biosolid that has historically been used as a fertilizer. So you might have heard of it as sewage sludge. Different parts of the country use it more frequently than others. The state that's had the most use of it has been Michigan, as far as I'm aware, because they have done the most research and have found the most contamination. But when sewage from households and businesses is sent to the wastewater treatment plant, then they separate the liquid from the solid, and then they have this, it's very nutrient rich sewage sludge, and the EPA has called it biosolids. And those biosolids are sold to farms. The EPA, the current rules allow it to be applied to pastures, to crops, even crops for direct human consumption. Federal law allows it. Some state laws have restricted it, but they can also be applied to tree farms, golf courses, other types of land. Again, it can also be bagged and sold at stores. And again, it's filled with PFAS. And so, again, as I said, Michigan is sort of on the front line of the PFAS response. And this is a picture that is from the Michigan State Department of Environment. And they kind of show the cycle of what happens. And then this gets into the groundwater, and then it goes into the water supply. And they're really trying to address the danger of PFAS in the water. Now, what's happened at the federal level? Well, the EPA on January 14th of 2025, so this was the end of the Biden administration, they released a draft sewage sludge risk assessment for PFAS and PFOA. And the assessment said that the acceptable risk thresholds can sometimes be exceeded when sewage sludge is applied on surfaces. And it focused on people that live near the farms or the people that are drinking water by those farms. And the final risk assessment has not yet been issued. And again, the whole purpose of this was to determine the potential health and environmental effects. Now, I am running out of time, so what I want to skip to is just highlighting what is going on in this area. So also the Biden administration in 2024, they established enforceable maximum contaminant levels for drinking water. So they were looking at how much PFAS can be in drinking water to be safe. And those were supposed to be implemented by 2027. Now, just 3 days ago, the EPA under the Trump administration issued proposed rules. You may have seen the headlines. It said they were scaling back. Essentially, the Trump administration is not abandoning this. They are still on board for imposing standards, but they have stretched out the compliance period to 2031. And so here was their announcement of the proposed rule to uphold federal drinking water maximum contaminant levels while strengthening practical implementation. And so there's an option for drinking water systems to request an additional 2 years to 2031 to comply with these enforceable limits. So we do have proposed rules. They're going to be stretched out to 2031, so they just won't be implemented as quickly as they were intended to be before. Now, there's another big part of this, and this has to do with the land contamination. And this is the last thing I'll talk about. But also in April of 24, during the last administration, the EPA said that two PFAS chemicals, PFOA and PFAS, were hazardous substances under CERCLA. Now, most of you are familiar with the federal law that says, this is a contaminant and it's called Superfund. Basically, you got to clean it up. And so what the EPA did in this rule, though, was to issue enforcement discretion. So in other words, the focus on enforcement is going to be on those that intentionally contributed to the PFAS contamination, not on farmers who might have, inadvertently put this fertilizer on their fields. That's not going to be the focus of enforcement. Like, they won't be subject to penalties and fines. But the idea is that they may down the road get help with some of this cleanup. And so here is the letter that was issued when these rules came out. Now, what we have from the current administration is that the Trump administration is still keeping the CERCLA designation that has been issued January 2026. That it's important that they're going to help work to have these Superfund sites cleaned, dealing with PFAS. That so apparently we have that continuing strategy. USDA in April, just last month, they issued their new regulations, their new framework for dealing with this. No, this is commissioned assistance to assess what they're going to do. So these aren't actually regulations yet. They're just assessing. I was looking at my time, realizing I was out of time. So the last thing I'll just say is there's also widespread litigation going on against some of the companies that were responsible for PFAS in the first place. 3M, DuPont, some of these companies that created these chemicals, they've already paid billions to settle lawsuits. So I think the thing I want to leave with you today is there is so much more to come in this space. It's just a very emerging area. And so I just kind of wanted to give you some background, give you the legal lay of the land. And if there are any questions at all, I'm here, even though I am out of time. There we go.
Please feel free to unmute, or you can type in the chat and I'll read them out for you if you have any questions. If you wanted to drop off, of course, we understand that too because of our timeline.
And you can also email me. I think that you'll provide the slides somehow. Is that correct?
Yes,
and so my email is right there. And so I'm happy to talk to anybody that wants to talk later. So thanks so much for being online.
Thank you. Doesn't seem like anyone's hopping in with a question, so maybe they're waiting to email them to you. So Kristine, if you just send me the slides, I'll take care of getting those out.
Sounds great.
Thank you, everybody, for your time today.
Thanks, everybody. Okay. Bye, Wendong.
Okay.